Hi, my name is Erich Straub with Straub Immigration, and this is a follow-up video regarding deferred action and the application process for deferred action. Now, if you don't know what deferred action is or whether it applies to you, my firm did an earlier video that discusses those concepts. So I would encourage you to go back and watch that video before you watch this. This video specifically pertains to the guidelines that were announced by the government on August 3rd, 2012 that further delineated the program. There's also something very important I need to tell you about this video, which is that it is for informational purposes only. By watching this video, you do not have an attorney-client relationship with Straub Immigration, because obviously, in order to do that, we would have to know the specific facts and circumstances of your case and tailor our advice to those facts and circumstances. So one of the areas that the government made clear in the August 3rd guidelines was the whole concept of continuous residence. So in the previous announcement, the government had indicated that continuous residence would start on June 15th of 2007. They clarified that individuals who were applying for deferred action would have to show continuous residence up until the date that they file the application. So in other words, you're going to have to show continuous residence from June 15, 2007 until the date that you file the application. Continuous residence is an immigration term, and it is a complicated immigration term, so we're going to talk a little bit about that term and what it means. So what about people who left the United States in that time period? Are they automatically disqualified from applying for deferred action? Well, not necessarily so, and the government gave us some guidance as to people who have left the U.S. who still may be eligible for the program. And so what the government told us was if the trip was brief, casual, or innocent, then it's not considered a break in the continuous residence requirement. So what does that mean? Well, really, it means four different things, at least as far as the government has defined it. And the first thing is that the trip had to be short, and that has been defined by the government as a trip that is reasonably calculated to accomplish the purpose for the absence. So basically, the government is going to ask you, if you have gone abroad, to tell them why you went abroad, and they're going to look at how long you were gone and determine whether they think that was reasonable. Now, the other three areas are all areas that break the continuous residence requirements. So, in other words, you did something that is going to cause it to stop and make you ineligible for deferred action. And so the government has stated that if you went abroad because of an order of exclusion or deportation or removal, that is going to break continuous residence. Another area where you would break continuous residence is if you were granted voluntary departure, either by the government administratively or by an immigration judge. The final area that would break continuous residence is if the purpose of your absence from the United States was contrary to law. So in other words, you went abroad to do something that was illegal. So let's talk about what we learned from the August 3rd announcement about the application process. One of the things we learned is that the form for the process is going to be available on August 15th. Another thing that we learned is that the government is going to accept filing of the form right away. The process is going to require that biometrics be taken. And biometrics are essentially the taking of fingerprints and photographs so that a background check can be run. Now, the fact that biometrics will be taken is significant, not because it's unusual. Every immigration process in the system requires biometrics to be taken. But it is significant because anyone who's applying for this program should be well aware that the government is going to take a very careful look at any criminal history that you have. And we deal with criminal history and some of the things that were talked about regarding disqualifications for criminal history in another video. So if you fall into that category or believe you may fall into that category, I really strongly encourage you to take a look at that video. Now, the final part of this application process would be applying for work authorization. And the government has said that anyone who files for deferred action is going to be eligible for a work permit, but they must show economic necessity. There is going to be a filing fee. There's an exemption for the filing fee, but the government has stated that it will only be applied in extremely limited circumstances. So I think it's the best course of action for applicants to expect to have to pay the filing fee. And finally, I just wanted to re-emphasize, this is a 2-year grant of deferred action, and the government said nothing in the guidelines that was contrary to that. So in this video, we've talked about continuous residence and that concept, and we've also talked about the application process for deferred action and that process, and we've given you an update based upon what the government released on August 3rd of 2012 regarding both of these areas. Another piece of information that the government has given us about the process is that there will be no appeal. And this really highlights the importance of seeking out good legal counsel, particularly good legal counsel from a competent immigration attorney. And there are a number of reasons to do that. First, you need to remember that there are risks involved in this process that you've got to consider before you file. The first and foremost being that you're informing the government that you are in the United States and without immigration status. Second, deferred action is a limited form of relief. There may be other forms of relief available to you that would allow you to get permanent residence and citizenship, and you're only really going to know that once you go in and talk to an immigration attorney who can consider all the facts and circumstances of your case and do a complete evaluation. And finally, there is always a risk in the deferred action process of being placed into removal proceedings and being deported from the United States. And this risk is particularly high for individuals who may have complicating factors in their case. As we have heard in this video, one of those complicating factors can be as innocent as a past trip abroad. If you're someone who has contact with law enforcement or a criminal record, you're going to be at a higher risk of having your application denied. So it is important that you seek counsel of an immigration attorney so that you can fully assess what the risks are to your case and make an informed decision about whether to go forward. At Straub Immigration, we have a reputation for achieving results in even the most difficult of cases. And whether your case turns out to be fairly straightforward or one of those difficult ones, I would welcome the opportunity to represent you.